Welcome back to another video, and today we're going to be looking at Schedule 3 of the Land Registration Act 2002 again. In the previous video we looked at paragraph 1 and paragraph 3 of Schedule 3 of the Land Registration Act, and in this video we're going to dive into paragraph 2 of Schedule 3 because this one is perhaps a little bit more meaty than the other two paragraphs. So this is Schedule 3 paragraph 2. And it says that an interest belonging at the time of the disposition to a person in actual occupation, so far as relating to land of which he is in actual occupation, except for an interest of a person of whom inquiry was made before the disposition and who failed to disclose the right when he could reasonably have been expected to do so. C. An interest which belongs to a person whose occupation would not have been obvious on a reasonably careful inspection of the land at the time of the disposition, and of which the person to whom the disposition is made does not have actual knowledge at the time. So we're going to break this down and discuss the elements of this. In brief, this paragraph protects interests, a right in rem, which belongs to a person in actual occupation of the burdened land. So it is allowing such rights to take priority under Section 29 despite their non-registration. So actual occupation. Now this is where we do case law because actual occupation is not defined in the statute. Its definition has been developed by judges over time. So we can use pre-2002 case law because the 1925 Act also contained the phrase actual occupation. So this is really what we're going to be doing now, is breaking down this concept of actual occupation, looking at case law. So physical presence. Now let's look at the case of Williams and Glinsblank and Boland per Lord Wilberforce. The legal question in this case was whether the beneficial interest under trust of wives in their family home could take priority over a subsequently granted right in rem, specifically a mortgage. So in this case there is a man, a husband, and he held the legal freehold of the land. He was the registered legal owner of the land. The wife had a beneficial interest under trust of the land, which of course is a right in rem. The husband then goes and mortgages the land to a bank, and the question was whether the wife's beneficial under trust took priority over that mortgage, whether it bound the bank, because if it did, then that would impact the ability of the bank to take possession of the land and sell it in order to recoup the debt owed to it. So the question, does the right in rem bind the bank? That's the main question. Now what we know about a beneficial interest under trust is that it cannot be registered against the land it burdens, so it cannot take priority via the registration channel. So if it is going to take priority, it would do so via the overriding interest provisions, in other words, via the provisions now in Schedule 3, but then in Section 70 of the Land Registration Act 1925. So the question really is whether the wife possessed a right in rem, which she did, and whether she was in actual occupation of the burdened land such as their right could take priority. Now for Lord Wilberforce this was very simple. He had no reservations about concluding that the wife was in actual occupation of the land. The land was the family home, and he said that actual occupation words are ordinary words of plain English and should, in his opinion, be interpreted as such. So he said that we should interpret actual occupation in the ordinary sense and the ordinary meaning of the phrase. Given actual occupation, in other words presence of the land, I do not think that the word actual was intended to introduce any additional qualification. It merely emphasizes that what is required is physical presence, not some entitlement in law. So Lord Wilberforce is really saying that physical presence on the land in this case was easily satisfied, so the bank could not repossess the house. But since then, the definition of actual occupation has been developed through further case law. So adapting to different property. Actual occupation needed to be developed, in particular where the property in question wasn't an ordinary sort of residential house. For example, a garage or a woodland or something like that. So actual occupation does not always equate to residence when it is not ordinary residential housing. So in Lloyds Bank and Rossett, the house was semi-derelict, and we're dealing with whether we can have actual occupation of the semi-derelict house by someone who doesn't live in it, but has some kind of presence on it. It was held that the test for actual occupation will have to be adapted because occupation of a semi-derelict property cannot equate to living in the property. It just equates to some kind of real presence on the land. So I'm going to read through what was actually said in this case. So I accept that in ordinary speech, one normally does equate occupation in relation to a house with living there. If a person is intending to move into a house but has not yet done so, he would not normally be regarded as having gone into occupation. That is the normal position, with a house which is fit for living. But that does not provide the answer in the present case, where the house was semi-derelict. So we have a semi-derelict house. So what's being said here is that we can't apply the same definition of occupation. What constitutes occupation will depend upon the nature and state of the property in question. So we can't just apply the same definition of occupation for a normal residential house and a semi-derelict house in this case. The paragraph applies to all types of land, and the acts which constitute actual occupation of a dwelling house, a garage or woodland cannot all be the same. It is perhaps dangerous to suggest any test for what is essentially a question of fact, for occupation is a concept which may have different connotations according to the nature and purpose of the property which is claimed to be occupied. So that was from a separate case. So we've really got this idea that occupation is sort of a fluid concept, and that we can't just say that occupation in one scenario will necessarily apply to a separate scenario. Occupation by an agent. Now, there was an additional complexity in Lloyds Bank and Rossett because the presence of the land was not on the part of the interest holder, which was the wife, but was the presence by her agent, in this case builders. So in Rossett, the wife herself, the person who claimed the interest, wasn't on the land much, but her agents, the builders, were on the land to the extent realistically possible, given it was a semi-derelict property, and they were essentially doing it up. So Lloyds Bank also engages with the issue of whether the physical presence of an agent can be regarded as a physical presence on behalf of the interest holder. So really the main question here is, can you occupy land through your agent? So if you're the wife trying to prove actual occupation of the semi-derelict property, can you use the occupation of your agent, the builders, and count that as your own occupation? And this is the question trying to be determined by the court. In this case, there was one dissenting judgment, but the court did decide, yes, that is fine. You can count occupation of your agent as your occupation and thereby prove that you are a person in actual occupation of the burden land and protect your interests over that land. Okay, and this is what was said. I can detect nothing in the context in which the expression actual occupation is used to suggest that the physical presence of an employee or agent cannot be regarded as the presence of the employer or principal when determining whether the employer or principal is in actual occupation. In order to constitute occupation, there must be occupation in person or by someone occupying as an agent for the purposes of the proprietor. This position is clearly from the judgment in Strand Securities and Caswell. Thus, occupation may be enjoyed through a resident caretaker put in the property by a tenant to look after it for him, but occupation by a friend for her own purposes, with the leave and license of the tenant, is no actual occupation. So really this is saying that in some circumstances and scenarios it is possible for occupation to be established through an agent, and in Lloyds Bank and Rossett that was through a builder. Fleeting presence insufficient. So in Abbey National Bank, Abbey National Building Society and Cannes, it was said that actual occupation does, in my judgment, involve some degree of permanence and continuity, which would rule out mere fleeting presence. A prospective tenant or purchaser who is allowed, as a matter of indulgence, to go into property in order to plan decorations or measure furnishings would not, in ordinary parlance, be said to be occupying it, even though he might be there for hours at a time. So really there needs to be some sort of permanence to the occupation for the court to constitute that there is actual occupation. You can't just sort of have a fleeting presence at the property. So this leads us on to two really important cases, Thompson and Foy and Link Lending and Bustard. And I urge you to read them because they have altered our understanding of actual occupation. These are very, very key cases, and I'm going to talk about each of them in turn. So Lewison was tasked with determining whether Mrs. Thompson was in actual occupation of Valley View, a residential property, at a time when she was not physically present at Valley View. So Mrs. Thompson had left the property 4 days before taking away with her a number of personal belongings, with only some of her belongings remaining at the property. And Lewison made 5 observations about the meaning of actual occupation. The first 4 observations he made were pretty orthodox. He was basically reiterating a lot of what Wilberforce said and Boland said, and quoting from that. But the last point he said was this: if the person said to be in actual occupation at any particular time is not physically present on the land at that time, it will usually be necessary to show that his occupation was manifested and accompanied by a continuing intention to occupy. So this last point looks quite revolutionary because it suggests that an individual can be in actual occupation of a property despite their physical absence, provided that during their absence they have a continuing intention to occupy the property. In other words, a lack of physical presence is not the end of the world in terms of actual occupation. A lack of physical presence can be remedied by a continuing intention to occupy. And this is something very new and bizarre, as it seems to fly in the face of what Wilberforce said in Boland. So the judgment. At the relevant time, Mrs. Thompson had decided she would not be returning to Valley View. Her lack of physical presence could not be remedied by a continuing intention to occupy. Lewison therefore held that Mrs. Thompson was not in actual occupation, yet had there been a continuing intention to occupy, Lewison would have reached the opposite conclusion. So this is important. If she had intended to come back to the property, he would have held that she was in actual occupation, despite not actually being at the property for 4 days. So he is applying his 5th observation here. Now, the first issue with this case is whether anyone would actually take this case seriously. Like, this is a High Court judgment, and his comments were strictly obiter, so the comments were not actually determinative. And the second issue is, if it is taken seriously, just how powerful is the remedial effect of this intention. So in this case, Lewison thinks that this continuing intention to occupy can remedy a physical absence for 4 days, but could it remedy a physical absence of 2 weeks, a month, a year, 5 years? Who knows? Just how powerful is this remedial effect of this continuing intention? Partial answers to these questions were provided in Link Lending and Bustard. So the Court of Appeal, less than a year later than Thompson and Foy, was tasked with determining whether Miss Bustard was in actual occupation of residential property at a time at which she had been physically absent from the property because she was sectioned under the Mental Health Act for a year. Mummery constructed a framework for assessing actual occupation under which he held the following to be relevant. The degree of permanence and continuity of presence of the person concerned, the intentions and wishes of that person, the length of absence from the property and the reason for it, and the nature of the property and the personal circumstances of the person. So you can see the language here is very different to the language used by Wilberforce and Boland. This text is very contextualized and is very subjective. For example, there's intentions and wishes. This does appear to endorse the High Court decision in Thompson and Foy. So the judgment was really, in this case, this is per Mummery, in this case the new and special features is in the psychiatric problems of the person claiming actual occupation. The judge was, in my view, justified in ruling at the conclusion of a careful and detailed judgment that Miss Bustard was a person in actual occupation of the property. His conclusion was supported by evidence of a sufficient degree of continuity and permanence of occupation of involuntary residence elsewhere, which was satisfactorily explained by objective reasons and of a persistent intention to return home when possible, as manifested by her regular visits to the property. So the Court of Appeal felt happily concluding Bustard is in actual occupation of the property, despite a year-long absence from it, because throughout her physical absence she continued to have an intention to return home. Her absence was involuntary, she didn't want to be in the residential home, her intention remained to return home to occupy the property. Now the comments are not obiter and are essential to the determination of this case. It is clear now, post-link lending, that if there is a gap in occupation, such that factually there is no occupation, this gap can be remedied by continuing intention to occupy. So this is a shift from Boland to this new contextualized approach compounded by Mummery in link lending. This case has also been applied in subsequent cases such as Thompson and Clydesdale Bank, which applied Mummery's rubric. It is worth pointing out that in both Foy and link lending, there was what the court construed a symbolic physical presence on the land. By this it means, although the right holder wasn't physically present on the land, some of the belongings of the person, for example the furniture, the bedding, was. It does seem that the court considered these things to be important. So what would happen if there wasn't a symbolic occupation, a physical presence? Is a symbolic physical presence essential for actual occupation when the right holder is not in occupation of the property? These are some questions that we must consider. So really, these cases really explain what actual occupation is all about. So now let's take a look at objectively obvious occupation. Paragraph 2 says that an interest belonging to a person in actual occupation will fall under the paragraph, except for an interest which belongs to a person whose occupation would not have been obvious on a reasonably careful inspection of the land at the time of the disposition. Now we can reformulate this as a positive requirement. If we do this, we can see the paragraph is demanding that the occupation be objectively obvious. So not only does the interest holder have to be an actual occupation of the burden land, their occupation has to be objectively obvious too. So the Land Registration Act 1925, section 70 is the predecessor legislation, and it has been repealed in its entirety and replaced by the 2002 Act. But as I mentioned earlier, under the 1925 Act we have a very similar provision that protected rights in rem of people in actual occupation in exactly the same way that we see in the 2002 Act. So this is the provision that corresponds with Schedule 3, paragraph 2. But this has now been written up to show that the requirement of objectively obvious occupation is new in the 2002 Act. Okay. So a couple of questions. What was the intended impact of the additional requirement that occupation be objectively obvious? What was the point in introducing the additional requirement in the 2002 Act of objectively obvious occupation? By requiring actual occupation and obvious occupation, the intention of the drafters must have been to limit the scope of paragraph 2, so to limit the interest that would override under paragraph 2. If you limit the scope, this is not so good for right holders, but good for purchasers. It is pro-purchaser because if an interest holder is in actual and obvious occupation, then on inspection of the land, you should notice their occupation and would have the opportunity to quiz them about rights they may have in it. And if those rights do bind you by Schedule 3, then you cannot really complain. So rights would only override under Schedule 3 paragraph 2 if the purchaser had an opportunity to find out about them. The second question is, what impact has the additional requirements had on post-LRA 2002 case law? Now, the answer, if I'm honest, is very little. In FOI, the obvious requirement is treated as adding absolutely nothing to the actual occupation requirement, and in link lending it is ignored. So why is this additional requirement of obvious just ignored? This is the sort of question you can ask yourself, but my thoughts are as follows. In link lending, it was a project of the court to protect the interests of Bustard because they sympathised with her position. They would have had a problem had it not been for FOI, because traditionally actual occupation would have required a physical presence on the land, and clearly Bustard was not physically present on the land. However, FOI allowed the Court of Appeal to do what they wanted to do. So the Court of Appeal leap on FOI and apply this new test of actual occupation, which allows physical absence to be remedied by continuing intention. And this allows them to say that Bustard is in actual occupation, thus bringing her under Schedule 3, paragraph 2. And this is what they want to happen. They want her interests to be protected because they like her. Their project of protecting that interest would have been frustrated if the court had gone on to insist on the obviousness of her actual occupation, because it is a stretch to conclude that she is in actual occupation, and it's even more of a stretch to conclude she is in obvious actual occupation. In fact, it is absurd. So, to take the obviousness requirement seriously would have frustrated the court's project, and it also would have rendered dilution of the test for actual occupation completely pointless. So the only sensible thing for the court to do was to ignore it. So it seems the additional requirement of obviousness cohered with Bonnard. It was sensible in 2002 as it would have restricted the scope of Schedule 3 paragraph 2, but it sits uneasily with our altered understanding of actual occupation. It's not clear how it can coexist with our diluted understanding of actual occupation, that it can exist even during the physical absence of an individual. So it's not really clear how obviousness can coexist with an occupation based on physical absence plus an intent to occupy, and the unease by which those two things sit alongside each other is manifested in linked lending, and the court decides to do nothing with obviousness at all. Yeah, I would recommend you try and develop your own thoughts about these questions, because they're quite interesting, and who knows, you may actually get a question about these in your exams, because it's a bit strange how I feel the court has dealt with these questions, and I think you should try and think of some of those thoughts for yourselves too. Time of the occupation. So an interest belonging at the time of the disposition to a person in actual occupation. That's what it says in Schedule 3, paragraph 2. So when must the right holder be in actual occupation? It is clear from paragraph 2 that the interest, right in rem, must exist at the time of the disposition, the completion of the transaction by the transfer and payment of purchase money. Lord Oliver and Abbey National and Can held that the actual occupation supporting the right in rem must also exist at the time of disposition. And in Lewis and J, in Thompson and Foy, reserved judgment on whether there must also be actual occupation at the time of registration. Okay, so what kind of rights does paragraph 2 protect? In theory, paragraph 2 provides a mechanism whereby any rights in REM can override. So in theory, paragraph 2 provides a mechanism for protecting any of them. So it allows any right in REM to override to take priority for the purposes of section 29, provided that right in REM is coupled with actual occupations. But of course, this is very much a theoretical position. Its practical impact is limited by the requirements that the right in REM must belong to a person in actual occupation of the burdened land and relate to the land occupied. Paragraph 2 therefore operates to protect only those rights in REM which entail occupation of the burdened land. So Claire owns Blackacre. She gives me a lease for 10 years over the land. She sells the land to someone else. My right in REM is a lease and exists over Claire's freehold estate, and crucially it entails occupation of the burdened land. I will be living on it as I have the lease. So if Claire sells the land on my if Claire sells the land on, my lease might well be protected under paragraph 2. Of course, if the lease is legal, we won't need the paragraph because we can just use paragraph 1. So really the main traffic is going to be around equitable leases. This is the same with the beneficial interest under trust. So say I own land and I hold it on trust for my brother. As the beneficiary of the land, my brother may have the right to go into occupation of it, so will be living on it. If I sell the land on, my brother's interest may well fall under paragraph 2. The sort of rights we are not thinking of when we're dealing with paragraph 2 include things like restrictive covenants. So Claire is the owner of Blackacre. Richard has a restrictive covenant restricting her from building on Blackacre. So Richard is a right holder. Is Richard in actual occupation of the burdened land? No, you see. So a restrictive covenant will not travel under paragraph 2, and none of the other paragraphs of Schedule 3 either. So to survive a sale of land or a disposition, they must be registered, as Schedule 3 will do nothing for them. In this bottom case here, this is a case in which the holder of an easement did claim to be in actual occupation of the burdened land, and that was dismissed. It was held that the use of the burdened land does not equate to occupation of it, and this seems obvious and simple. So paragraph 2 is very good at protecting the rights in REM that actually entail occupation. It won't protect rights like easements and covenants which do not entail occupation. And so just to finish this off, let's look at an example. So Blackacre example. Claire is the registered proprietor of the registered freehold in Blackacre. In October 2013, she leased Blackacre to Sophie for a term of 5 years. The lease was not granted by deed, but Claire and Sophie entered into a written document signed by both of them outlining its terms. Sophie moved into Blackacre immediately, taking with her all her earthly possessions. Last month, Claire sold Blackacre to Polly, who is now registered as proprietor of the freehold estate. Polly failed to inspect Blackacre pre-purchase and is now shocked to discover Sophie living there. She insists that Sophie move out immediately. Advise Sophie. So how to structure this answer? Now, you find out the nature of rights in REM burdening the land. You want as much information about them as possible as you possibly can. So for example, whether their content satisfies the law's template of a right in REM, such as if they have the content requirements of an easement or covenant. So categorise the right in REM that exists over the land. After you've done that, you want to find out whether the right is legal or equitable. And I have a video on that. If you haven't seen it already, go check that one out. And this is important as this may have an impact on how powerful the right is. Then you want to apply the relevant rules in order to determine the impact of those rights in REM on a disposition of the land. Okay, so in this example, Claire is the owner of Blackacre. She is the registered proprietor of the registered freehold. And we know we are dealing with registered land, so we would open up the 2002 Act. We are told in October 2013, she grants a right over her land to Sophie. So the first thing to do in terms of our structure is to work out what Sophie's right is. Is it a lease, easement, covenant, etc.? And this will depend on its precise content. And we will do more on the content of the various rights in REM in other videos. But That's okay for the minute. Then we will be asking whether that right is legal or equitable. And once you're happy that you have done that, you have to work out the impact of the right on someone who subsequently takes an interest in the land. Often the person who takes the later interest in the land will be a person who takes the freehold, just a straightforward purchaser of the land, as we do here. And in this case we have the registered land, Blackacre, and we have Claire selling Blackacre to Polly. So Polly is our person with the new interest in the land and has acquired a freehold over Blackacre. And we want to know what the impact of the pre-existing rights are on Polly. So we want to know whether Sophie's right takes priority over Polly's. In other words, whether Sophie's right binds Polly, because then that will determine the question about whether Polly can kick Sophie out. Now, I personally like to start with the real life situation when answering a problem question. So here, Polly is the owner of Blackacre and she is the owner of the registered freehold. But there is somebody living on her land, Sophie, and she wants to get rid of them. And the question is, can she? If Sophie has an interest that takes priority, binds Polly, then Polly won't be able to get rid of Sophie. If, however, Sophie's right in rem is not binding on Polly, then Polly can get rid of Sophie. In order to work out whether Sophie's right binds Polly, we need to know what Sophie's right is. So once we find out that Sophie has an equitable lease, we can then work out its impact on Polly by applying the rules in section 28 and section 29, and then cross-referring if we need to Schedule 3. Okay, so Claire is the registered proprietor, and she leases Blackacre to Sophie for a term of 5 years. However, we do not know whether the lease is legal or equitable. What we do know is that a lease is a right capable of being legal. And that's stated under Section 1 of the Law of Property Act. But we know that rights that are capable of being legal will only achieve legal status if created with the requisite formality. Now, this lease is for a term of 5 years, so under Section 27 of the Land Registration Act, registration is a requirement for leases of 7 years and over, so registration is not necessary for our 5-year lease to achieve legal status. So what is going to be necessary is a deed, and that is stated under Section 52 of the Law of Property Act 1925. But this lease in this example was not granted by deed, therefore it is not legal as our formality requirements have not been satisfied. But this is not the end of the story, because if you have a potentially legal right that has not achieved legal status because of a lack of formality, you need to ask whether it can take effect in equity. And here the law looks as done as ought to have been done. Contracts to confer, written and signed by both parties. And if the contract is written and signed by both parties, the law will presume there is a valid lease. So although this isn't an estate contract, for example, a contract stating an easement will be granted in 6 months, equity will treat it as one, making it an equitable lease. So Sophie has an equitable lease under Parker and Tazwell because the formalities attending the failed grant is written documentation signed by both parties. So under Parker and Tazwell, the law will instead construe the failed grant as a valid contract to grant, and it will thereby grant an equitable lease. We now need to determine what the impact of this equitable lease has on Polly. Sophie moves immediately into the property, taking all her possessions. Now, this is a registered land, so we are dealing with the Land Registration Act 2002, and our provisions that determine the impact of pre-existing rights in rem on a new interest holder are Section 28 and Section 29. So, the first point of call is Section 29, and we want to see if this section is engaged on our facts. Remember, what the section says that it has a kind of if clause. If a registrable disposition of a registered estate is made for valuable consideration, completion of this disposition by registration has the effect of postponing to the interest under the disposition any interest affecting the estate immediately before the disposition whose priority is not protected at the time of the registration. So we want to see whether the clause is satisfied on our facts to determine whether section 29 is engaged. So whether section 29 governs the impact of Sophie's right on Polly. So this is a transfer of the freehold from Claire to Polly. A transfer of the freehold is a registrable disposition of a registered estate under section 27. We can infer also that this disposition has been made for valuable consideration because we are told Claire sells to Polly, which indicates money exchanges hands. The disposition of the transfer has been completed by registration, so Polly has been registered as the new proprietor of the freehold. Therefore, the if clause in section 29 has been satisfied. There is a registrable disposition for valuable consideration and it has been completed by registration. This means, as we have satisfied the if clause, we can apply the rule in section 29. The rule is that pre-existing rights in rem will bind the new interest. They will take priority over the new interest if either they are registered or fall under Schedule 3. So has this easement been registered or no? So this route is not available to Sophie, so we have to look at other channels for when a pre-existing right in rem can take priority, and that here is Schedule 3. So we flip over from Schedule 29 to Schedule 3, and that will be quite a common pattern you will encounter when dealing with problem questions like this. So looking at Schedule 3, we need to ask whether Sophie's right falls under any of the paragraphs of Schedule 3, because if it does, then it will take priority over Polly's freehold. We know that Schedule 3 paragraph 1 deals with leases, so we might go there first, but this is going to be a problem as this deals with legal leases only, and Sophie does not have a legal lease, so it won't be able to override under paragraph 1. But we also have paragraph 2, which is essentially especially good at protecting rights in rem which entail actual occupation, as a lease does. So paragraph 2 protects interests belonging to people in actual and objectively obvious occupation, but there is a question mark over whether objectively obvious occupation is actually necessary, as we discussed earlier. So is Sophie in actual occupation of Blackacre? Because if so, paragraph 2 will work to protect her interests. And from the facts of the case, we can assume she does have actual occupation, so her interests will fall under paragraph 2, meaning her priority is protected under section 29 over Polly's freehold estate. So Polly will be bound by Sophie's right in rem. Okay, so this is the end of this video. I know that was a very long one, but paragraph 2 of Schedule 3 is quite chunky. There's a lot to talk about and a lot of things to think about, especially at this understanding of actual occupation, and we had to look at the case law as that is the only way we're going to find out the definitions of these particular aspects of the provisions. If you have any questions at all about this video, please leave a comment below and I will get straight back to you. And make sure you subscribe to my channel because I'm going to be uploading videos daily. Thanks for watching.